Have you ever watched a courtroom drama where, right at the end, a piece of evidence comes out of nowhere and changes everything? The whole room gasps, the jury looks shocked, and the lawyer slams their briefcase shut. Well, what if I told you something even more dramatic just happened in real life? This isn't a movie script. It's the story of a high-profile trial that had everyone on the edge of their seats, only to end with a legal maneuver so bizarre, so unexpected, that even seasoned lawyers were left speechless. Get ready, because the story I'm about to tell you is crazier than fiction. The case revolved around billionaire tech mogul Julian Croft. Croft was the charismatic founder of a revolutionary clean energy company, lauded as a visionary. But behind the scenes, allegations were swirling. He was accused of orchestrating a massive fraud scheme, bilking investors out of hundreds of millions of dollars. The media frenzy was intense. Every news channel, every blog, every podcast was covering the Croft trial. It was the trial of the decade. The prosecution seemed to have an ironclad case. It had mountains of financial records, damning internal emails. And a star witnessed Croft's former chief financial officer, a man named Marcus Thorne. Thorne was the linchpin of their entire argument. He was the insider who could connect Croft directly to the fraud, painting a picture of a brilliant mind who knowingly deceived his investors for personal gain. The prosecution's opening statement was powerful. They laid out a clear timeline, showing how Croft allegedly funneled money into shell corporations, living a life of unimaginable luxury while his company's stock plummeted. The public was convinced. Croft was going down. For weeks, the trial unfolded just as you'd expect. Witness after witness took the stand. Financial experts detailed the complex web of transactions. Former employees spoke of a corporate culture built on secrecy and pressure. Through it all, Julian Croft sat at the defense table, looking calm, almost detached. His legal team was top-notch, of course, led by the legendary defense attorney Eleanor Vance. They chipped away at the prosecution's case. They questioned the validity of the documents, suggested other executives were responsible, and painted Croft as a hands-off innovator who was too busy changing the world to be bothered with spreadsheets. But everyone knew the real battle would be the cross-examination of Marcus Thorne. When Thorne finally took the stand, the tension in the courtroom was palpable. He was composed, articulate, and his testimony was devastating. He walked the jury through emails he claimed were from Croft, detailing the exact mechanics of the fraudulent scheme. He described late-night meetings where Croft allegedly boasted about being untouchable. It looked like the nail in the coffin. The prosecution rested its case, confident they had secured a conviction. The media was already running headlines. The innovator's deception. Croft's empire crumbles. Then, it was the defense's turn. Eleanor Vance stood up, her expression unreadable. Everyone expected a grueling, aggressive cross-examination. They thought she'd try to discredit Thorne, paint him as a disgruntled employee, or maybe even suggest he was the real mastermind. But she didn't do any of that. Instead, she walked calmly towards the witness stand and asked a simple question. "Mr. Thorne," she said, her voice steady, "are you familiar with the legal principle of adverse possession?" The courtroom went silent. The judge looked confused. The prosecution objected, calling the question irrelevant. What on earth did a real estate doctrine, which allows someone to claim ownership of property they've openly used for a long period, have to do with a financial fraud case? The judge overruled the objection, intrigued. Vance continued. She asked Thorne about his old office, the one he occupied at Croft's company for over 10 years. She asked if he'd ever changed the locks, if he had the only key, if he treated it as his own exclusive space. Thorne, looking bewildered, answered yes to all of it. Then Vance dropped the bombshell. She presented a motion to the court, a motion so audacious it had never been successfully used in a criminal trial of this nature. She argued that under a radical interpretation of adverse possession, Marcus Thorne had effectively become the owner of the information and data stored within his office and on his computer, because he had exercised exclusive control over that domain for a decade. She argued the evidence he provided, the emails, the financial records, all of it was technically his own property, not the company's. The prosecution lawyers were literally laughing. It sounded like a joke, a desperate Hail Mary pass from a defense team that had run out of options. But Eleanor Vance wasn't joking. She had spent months building this argument, citing obscure legal precedents from centuries-old property disputes and creatively applying them to the digital age. She argued that since the evidence was Thorne's property, he wasn't a whistleblower revealing corporate secrets. He was a co-conspirator turning over his own incriminating files. And if he was a co-conspirator, his uncorroborated testimony against Croft was inadmissible without a plea deal or immunity, neither of which he had. The legal world was thrown into chaos. For days, the trial was paused as legal scholars and the judge wrestled with this unprecedented argument. Could a legal principle designed for forgotten parcels of land be applied to digital data in a corporate office? Was this a brilliant legal innovation or a complete bastardization of the law? The prosecution argued it was absurd. They claimed it would create a loophole allowing any employee to steal company data and then claim ownership, turning every corporate crime into a tangled mess of property law. But Vance was persuasive. She argued that in the digital age, our concepts of property and ownership need to evolve. An office you control? A computer only you use, isn't that a form of possession? The judge, a well-respected jurist known for his intellectual curiosity, was clearly captivated by the novelty of the argument. After a week of deliberation, he returned with a ruling that sent shockwaves through the entire legal system. He agreed with the defense. In a lengthy, detailed opinion, the judge ruled that Thorne's exclusive, long-term control over his office and digital files met the threshold for a form of digital adverse possession. Therefore, the mountain of evidence he provided was legally considered his own. As a result, his testimony against Croft was that of an accomplice, and without independent corroboration, it was thrown out. The prosecution's case was instantly gutted. Without Thorne's testimony and the documents he provided, they had nothing. All their other evidence was circumstantial. So the next day, the prosecution had no choice but to drop all charges. Julian Croft, the man everyone thought was destined for a long prison sentence, walked out of the courthouse a free man. He didn't smile. He didn't speak to the press, just got into his car and was driven away, leaving a media circus and a legal system in absolute turmoil. The outcome was so stunning, so contrary to all expectations, that nobody knew how to react. Was this justice? Or was it a masterful, cynical manipulation of an arcane legal loophole? The legacy of the Croft trial is still being debated. Legal schools are now teaching courses on digital property rights and the Vance Doctrine. Lawmakers are scrambling to close the loophole, to clarify the laws so this can never happen again. But for one brief, shocking moment, a forgotten rule from the 17th century reached into the 21st and completely upended a billion-dollar fraud trial. It serves as a wild reminder that in the theater of the courtroom, the script is never truly finished until the final curtain falls, and sometimes the biggest twist is the one that was hiding in a dusty old law book all along. What do you think? Is this a stroke of legal genius or a miscarriage of justice? Let me know your thoughts in the comments below. And if you enjoy stories about the strange and unexpected ways the world works, make sure you hit that subscribe button and turn on notifications. You won't want to miss what we have coming up next. Thanks for watching.